resolution were to be quashed or set aside, then by operation of law, the status quo ante will be restored, thereby effectively creating a scenario where there will be two deputy presidents in office at the same time. The impeached deputy president, reinstated by judicial fiat, and the successor duly appointed under Article 149, sub-Article 1. We have no doubt that Kenyans did not intend such scenario, and the Constitution does not contemplate dual incumbency in the president. Accordingly, while the infringement of fair trial rights is acknowledged and vindicated, it does not undo the impeachment itself. The appropriate remedy lies in declaratory reliefs and damages to vindicate the Constitution, not in quashing the Senate's resolution. In light of the foregoing, that is not to say that His Excellency Gachagua has no constitutional remedies given the violation of his rights. As we said, we are convinced that this is a case where the infractions on the part of His Excellency's right can be adequately vindicated by way of appropriate declarations and damages. Applying Gitwabu Imanyara's case, it is our position that the violation of His Excellency Gachagua's fair trial rights during the impeachment proceedings calls for a remedy that goes beyond mere acknowledgement. Declaratory relief serves to formally recognize the infringement, while damages will provide redress and underscore the seriousness of the violation. This amount is not intended to compensate for the loss of office, but rather to vindicate the Constitution, restore the dignity of the affected party, and deter similar infractions in future impeachment proceedings. Lastly, we find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective course. Given that the Gitobu case was resolved a decade ago with Mr. Gitobu receiving damages of 15 million, the lapse of time justifies an upward adjustment of the award.
These are now the final orders. Arising from all that we have said, these are the orders that we make. 1, the prayer seeking to quash the resolution of the Senate to impeach His Excellency Gachagua is hereby declined. 2, a declaratory order is hereby issued that His Excellency Gachagua's fair trial rights were infringed when the Senate declined to allow an adjournment in the impeachment proceedings despite his absence. 3, a declaratory order is hereby issued affirming the constitutional necessity for Parliament to enact a dedicated statutory framework governing the impeachment of Deputy President under Article 150 of the Constitution. 4, the court makes no findings on pension and emoluments. The first petitioner is at liberty to pursue the matter before an appropriate forum. 5, the court awards constitutional damages of Kenya shillings 50 million to His Excellency Gachagua payable by the Senate to vindicate the Constitution, restore the dignity of the affected party, and deter future violations. 6, parties shall bear their own costs given the public nature of these proceedings. And lastly, for the avoidance of doubt, any prayer not expressly allowed herein is accordingly disallowed. Before we take leave of this matter, we wish to record our appreciation to all counsel who appeared in these proceedings and all parties for their industry, diligence, and the quality of their submissions. Your collective effort has contributed to the development of constitutional jurisprudence on this subject. We also extend our gratitude to the judiciary staff who worked tirelessly to support the bench in ensuring that this decision, the first of its kind under the Constitution 2010, was rendered in time. Thank you very much.